The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Good morning. Court Radio is now in session. Call 215-227-2727. When you've got legal questions, we've got the answers. This is Court Radio. And now here's your host, Dean Weitzman.
Good morning and welcome back. It's Court Radio time, and we've got your legal back. I'm joined in the studio. You know him as Mr. Workers' Compensation, Mr. Jeffrey Gross.
Good morning.
Hello, Jeff.
How are you today, Dean?
I'm doing well, thanks. Thanks for joining us. I know when you're here, folks always have those pesky workers' compensation questions.
Yes, and I do not consider them pesky.
There you go. What a gentleman. Folks, if you're listening and you want to ask a question, today's the time to ask your workers' comp questions or any other legal question you have. All you got to do is give us a call at 215-227-2727. It's the simple number that you can remember or keep on your cell phone. And during the week, that's the number to My Philly Lawyer, 215-227-2727. I was up late last night.
Why were you up late last night?
I had a birthday party for one Lisa Collins. That's right. We were down at the African American Museum. Partay.
Nice.
Yeah. But, you know, I overstayed my welcome because I have to get up early on Sunday mornings. So anyway, but you know, some crazy news this week, Jeff. Down in Texas, everything crazy happens in Texas, by the way. You know, I mean,
it's a big state.
Yeah.
Very conservative.
Very. So U.S. armed marshals arrested at gunpoint a guy. What do you think his crime was?
It wasn't for fleeing somebody.
No, it wasn't for fleecing or fleeing or beating or drug dealing. Or he owed $1,500 in student loans. That's right, folks. Your government, the United States government, is now arresting people at gunpoint if they owe student loans.
Talk about a waste of resources.
This poor guy came out to get the mail and was surrounded by 7 U.S. Marshals and taken down to federal court to answer to the judge for his $1,500 student loan. How's that sound?
And I'm guessing that he couldn't pay it.
Yeah, he got on a payment plan real quick. He was on the $200 a month payment plan. It was that or go to jail.
I'm curious how much it costs to have those federal marshals come down and get him.
Well, yeah, probably more than he owed. Exactly. With interest and penalties.
Like I said, another waste of resources.
Right. You know, there was a time, folks, when, and it wasn't that long ago, when student loan debts were actually dischargeable in bankruptcy. Then one day, the Republicans came to office. It's like a fairy tale. The Republicans came to office, and they decided that they were going to give the student loan debt a special treatment. And unlike mortgages, car payments, you can name any kind of debt in the world. If you are bankrupt, you can get out of it.
Except for domestic debt.
But not, well, you mean child support?
Yes.
Yeah, child support. Well, you know, you got to support your child no matter what. But do you have to support the federal government / all of these universities who encourage people to come in, and even though there's no jobs available, and encourage you to incur $100,000 in debt?
There are other ways for the federal government to derive revenue if they really wanted to.
Yeah, it's a crazy, crazy world, you know, whatever. But anyway, you know, that's what's going down in Texas. And the rest of this stuff I'm not going to bore my listeners with, except to say that this week, folks, because we've talked about it for many, 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 many months, but this past week, Governor Tom Wolf signed the expungement bill. The expungement bill that my friend Jordan Harris had a hand in crafting, along with a few other decent legislators. There are a few. And it is now the law. But it takes 9 months, like having a baby. It takes 9 months for the law to come into being. So you can't start filing those expungement petitions for 9 months. But at the end of this year, I guess sometime in October or November, it actually becomes effective. And at that point, if you've got a M2 or M3 prior offense that's more than 10 years old and you've been good since then, you can get it wiped away. No felonies yet, so don't ask, don't try. No felonies and no misdemeanor ones, but all misdemeanor 2s and 3s, and of course, summary offenses and arrests and all that stuff. That's always been expungible, and it continues to be. But now they've included 2 classifications of crime, and usually it's for like theft under $200, things of that nature. If you've got a shoplifting charge on your record and you want to get rid of it, and when you were a kid and you're now a law-abiding citizen, those are the expungible offenses. And frankly, and I make no bones about it, I hope that this is not the end of this line. It's the beginning, because I believe, Dean Weitzman believes, that everybody, pretty much, maybe not everybody, but 99% of the people deserve a second chance.
People make mistakes.
Absolutely. Absolutely. I include myself in that. 215-227-2727. You got legal questions? Jeff and I have the answers. All right, Jeff, let's talk workers' comp real quick.
Yes, sir.
What happens, it doesn't always go smoothly. What happens when you're working someplace and they hassle you? They try to force you not to make a claim. They try to, they call you every day when you're out, and they just keep hassling and hassling. How do you get around that?
So that happens. I mean, look, people are in a situation, if everything ran smoothly, I wouldn't be needed, right? So here's the deal. If your boss or anyone that's supervisory to you is hassling you about a work injury where you have gone out of work and you just are in bad shape and they want the return on their investment, they're paying you, they want you back so that they don't have to keep paying you, or so that you're going to be somewhat productive to their interests, they will do what they can to get you back by, for instance, they will call you, they will harass you, they will say, when are you coming back? When is your doctor going to send you back? We have a job for you. When? And they'll send you letters. And you feel that if you don't respond, you are doing the wrong thing. And you aren't doing the wrong thing. It's just that there are the eyes of the law that look at the situation and say, well, what's the reasonable person do? What does the person who's acting in good faith do when that happens? And the easiest thing to do in the world is to simply call me, because I can give you the advice, and each case is different, obviously. But generally speaking, communication is the key to success in most instances. Remember that. So if you're being called, you don't have to dodge the calls and just put your head under the covers. You can address it. And if you're afraid to, you call me and I'll tell you how. But if you address it by communicating with the employer and telling the employer how significant your injury is and how bad you are, and that the doctor has not released you to return to work yet, that should be sufficient unless you're given a specific job offer.
Okay, and what happens? Well, we'll talk about what happens when you get a specific job offer, but let's go to line 4, Larry. And Mike from Camden, good morning and welcome to Court Radio.
Good morning. How you doing?
We're doing wonderful. I hear you got a workers' comp question, Mike.
Yes, I'm going to try to make it as simple as possible. Well, I had a real complicated workers' comp case. I had so many injuries, it's pathetic. And we went to court, and I was thinking about going to trial. My attorney told me no matter what, whatever I do, the settlement they agree with now, it would be no more. I kept saying, well, why can't they go ahead and pay me now? They said New Jersey law said this and that. But whatever you do, you can't get no more. So I went on, signed an agreement, right? And they agreed to pay me $1,000 a month. I'm asking, why can't I get all my money? And said, you can't do it in New Jersey. So after the case got settled, I'm doing an investigation, and I found that I could file under duress. And I'm trying to figure out how can I get all my money, because they said once they pay me all that they owe me, then they'll start paying me each month. I don't think that is fair. They should start paying me from that date. Instead of what they owe me, they start paying me.
All right, Mike, here's your answer now. Sit back and listen. Basic question. You sign an agreement, okay, a release agreement, and then you have second thoughts. Can you get out of that? How hard is it?
The answer is simply no. And the problem is that once you sign an agreement and it gets ratified or adopted by a judge, it's no longer an agreement. It's a court order. Once you have a court order, that's it. That's a court order. And this is a non-reversible agreement generally. So what will happen is you will sign the agreement, the judge will approve it, and then you're stuck with what you've signed and what the judge approved, which namely is, in your case, to get paid at periodic payments. There are ways that you can accelerate those payments, not by the employer or the insurance carrier, but by a third-party lending institution that will gladly give you all of your money now for a discount so that they can make some money, and that usually is very ridiculously high. So you've seen them on TV, I'm sure, where they'll say, we'll buy out the remaining part of your annuity or your periodic payment, and we will take a check for X amount, which is a large percentage. And that's kind of like highway robbery. But if you need the money, you need the money.
All right. So generally speaking, once you sign an agreement, there's no getting out of that agreement. No duress. But if it were true duress, if your lawyer had a gun to your head while you were signing the agreement, we probably could get you out of it. But literally, you'd have to have some kind of drastic measures.
The only way around it is if there is a mutual mistake of law or fact. For instance, you thought you were getting a certain thing and you didn't know you were getting periodic payments, and they didn't realize they were paying you that way either. That's one way, but it has to be a mutual mistake. It can't be a unilateral or one-sided mistake.
In third-party law, if you're signing a release and you've agreed to accept a certain amount of money, and then subsequently you have your injuries don't get better, you realize, my goodness, I'm really messed up more than I thought I was. That wasn't enough money. Too bad. Too bad. The court doesn't want to be inundated with people who have second thoughts about their agreement. So there's virtually no getting out of the agreement. Now, if your lawyer told you there was only a $15,000 policy, so sign this release for $15,000, and the lawyer made a mistake, you might have a legal malpractice claim, but you're not going to be able to undo the release itself.
So workers' compensation is the same way, except you don't have to agree to something that you don't want to agree to. And sometimes when your lawyer or anyone tells you this is as much as you're going to get, you're not going to get any more, then, sometimes you should go for a second opinion. It's no crime to get an opinion from another lawyer who can shed light on the situation. Two minds do not always think the same way.
Have you given second opinions?
All the time.
All the time, folks. All you got to do is give us a call at 215-227-2727. Jeff's offices and my offices literally share the same floor in the same building. We tear up the carpet every day going back and forth to each other's offices. So do not think twice. All you got to do is give us a call, and your questions will be answered. Let's talk to Ms. T from Overbrook. Good morning, and welcome to Court Radio.
Good morning. My question is, my husband was involved in an accident.
Wait.
His car, was damaged.
Hold on a minute. Do you give Ms. T to remain anonymous? Was that the motive behind the Ms. T?
It's just easier easier and short and to the point.
Okay. All right. So your husband was involved in an accident,
His car was damaged,
but he wasn't.
and one of the towing companies came, and he allowed them to tow the car until he could figure out where he wants to take it for body work, and, he's going to call his insurance company and all. What's the procedure for getting that car out of that storage facility?
Paying money.
So what do you have to do? Does it come out of your pocket or your insurance company pays it?
Well, the answer is if you have collision coverage or property damage coverage, then it'll come out of your insurance.
Okay, he's fully covered.
Okay. So if he's fully covered, he's got collision coverage on his vehicle, and collision coverage will pay for towing and storage as well. And so his insurance should be happy to retrieve the vehicle, pay what needs to be paid. Now, of course, that reduces your coverage. So if you've got whatever, $5,000 in property damage or $10,000 in property damage, and you spend $1,000 in towing and storage, now you've got $4,000 or $9,000 or whatever, and to repair the car. They'll never pay more than you bought, but yes, it's covered. And if somebody caused the accident, not him, not his doing, but it's some at-fault party, then they will pay.
Gotcha. When he finds out where he wants to take the car, does he just call his insurance company and they'll take care of everything?
Well, no. He would call the place he wants to take the car. They'll usually send a tow truck over to retrieve the vehicle, but they won't be able to get it until the place that it's at has been paid. So you got to get your insurance company on the line with the people where the car is so they can arrange for payment, and then you can go retrieve the vehicle by the place that he wants to have the work done at.
Got you. So they'll come and pick the car up.
Yeah, absolutely.
The body shop.
Yep.
You've been so helpful. Thanks, Dean.
All right, Miss T. Thanks for calling Court Radio, dear. Have a great Sunday.
Okay.
Folks, Jeff Gross is in the house, and if you've got workers' comp questions, we probably have the answer. I don't ever think he's been stumped before, but I dare you to try.
Try me.
215-227-2727. So, Mr. Gross, you're out of work, okay? And and the insurance company for workers' comp wants to send a stranger, they call a nurse, with you every time you go to the doctor. Are they allowed to do that?
Wow, that's called a nurse case manager. They happen to exist more than we like. The nurse case manager is a very friendly person. They usually assign the same-sex person to the person who is injured. So if it's a man, you get a male case nurse. If it's a woman, you get a woman case nurse. What they're trying to do is minimize the cost on the claim medically. So what they do is they have this nurse case manager be real nice to you and get your trust so that you talk to him or her.
Oh, can you talk to them?
Well, listen, I don't allow contact between my clients and nurse case managers, but that's what they do. Once they know that I'm involved and I say, no way, Jose, they back off.
Aren't they an advocate for the patient? Don't they want... No?
Not even almost. They are advocates for the insurance carrier here, because what they do is after you're done your little meeting with the doctor, your little appointment, they like to talk to the doctor. And what they tell the doctor is, hey, when can we get Joe Schmo back to work? Because we have a job. We can get a job for this person. We can make any restriction that you have an accommodation for this person. So they talk to the doctor, and when the doctor says, listen, this guy is really messed up, he can't go back to work, they say, well, what kind of restrictions do you have, doc? And they'll get restrictions from the doctor, and then they'll carve out a job with restrictions to get the injured worker back to work in a modified duty or light duty position, accommodating the restrictions, and then they don't have to pay workers' comp anymore.
So they do get to come with you to your appointments.
Well, they only get to come with you to your appointments if you're unaware of it and you allow it. Remember, if you allow it, A lot of things can happen.
But if you say no, they don't. Then they don't get to come into the appointment.
Well, first of all, they're not allowed to come into the examination.
Okay.
With you.
Right.
But generally speaking, they can talk to the doctor because 9 out of 10 times, if you're unrepresented, you're going to their doctor. And if you're going to the employer's doctor or the insurance company's doctor, the doctor's going to cooperate with the nurse case manager because who picked that doctor in the first place?
The employer.
The employer. And who's paying for that doctor?
The employer.
So if the employer's paying, the doctor will talk. Remember one thing, you would think, what's the first thing you think of? HIPAA. HIPAA. You know what HIPAA is?
Yes. My HIPAA is hurting me.
You can't disclose medical information to a third party without your authorization. That's generally what that means. Workers' compensation is accepted out of the HIPAA regulations.
So there is no patient-doctor confidentiality. They can talk about your stuff to anybody, including the case nurse manager.
Unless you pick the doctor and you say no.
Wow, okay.
Now, when I'm involved, we help with the designation of the physician because I believe that you have the right to very good, if not excellent, medical treatment and very good, if not excellent, patient advocacy. And the doctors will usually help you because you are their patient, as opposed to the doctors that are hired by the insurance carriers who will help them because guess what? You're only one patient. They want more. And where are they going to get more? From the same people that sent you to them.
215-227-2727 gets you that kind of advocacy, really. And people just kind of don't know what to expect. And it's a very stressful time. They've just been involved in some sort of an incident, accident. They've sustained injuries. You know, they're not at their best right now. And then the phone rings, and it's some nice-sounding woman who says, hey, I'm here to help you get better. And, I work for the insurance company, and I'm going to show up at the appointment, or I might take you to the appointment. And, then you chat on the way over. So what you're saying is, no, you don't talk to that person at all.
Well, yes, you don't have to be a mean-spirited person. You don't have to be an angry person.
You don't have to be Dean.
Well, I don't think you're angry. You just stand up for yourself, and there's a difference. But you don't have to do that. You can be really nice to everybody and still maintain your rights. And the easier thing to do is to call me so that I can have a discussion with the adjuster and with the nurse case manager and write a letter of representation which excludes their participation with you directly. So that way they will talk to me. And I'll be happy to be cooperative with them, but I am not allowing a nurse case manager in the appointment with the doctor that you choose, and I am not allowing that person to talk to you directly.
All right, let's talk to Kevin from West Philly, who's got a comp question. Hey, Kev, welcome to Court Radio.
Good morning, you guys. The dream team of the law. I like that. And Mr. Jeff, I'm hoping I'm addressing your name right. Mr. Jeff, I believe you're the man above all men to shed some light on this worker comp question.
Okay,
and
Kevin.
It goes like this. I have got hurt on a job 17 years ago. Fought hard to get workers' comp. Now, still receiving workers' comp. When is it at a point they're going to cut me off? Because I'm on edge every day that they're going to cut me off and bills going to be haywire. What's going on with that, Jeff? Please shed some light on like I'm a 2-year-old. Please tell me.
Absolutely, absolutely. What you are facing is a big question mark, an unknown. You don't know where your future lies, and you don't have a plan, and you don't have a strategy. And what happens is you are getting benefits, rightfully so, and you just don't know what's going to happen, when you're going to end it, how you're going to end it. You probably need a strategy, and that's what I'm here for. So what has to happen, first of all, is they or you have to make the first move, or you can stay in the same pattern that you're in right now if you're satisfied. The problem is you just don't know what to expect, and that's what I can do. I can give you an expectation of where you're going.
So let me say, he's on for 17
Yes.
years.
He's one of the higher ones. I got to tell you.
Yeah.
People don't get on and stay on for that long because of the tools of the carrier and because of the individual's motivation to get off.
And besides which, I mean, Kevin has to be being paid based on a wage rate that's 17 years old.
That's correct. Your wages and your wage rate are fixed as of the date of your injury. Even though the cost of living has gone up in this world, your wages, unfortunately, are going to remain the same, and they're fixed as of the date of your injury.
So, can Kevin wrap this up and get a lump sum of money today?
Yes, that's called a compromise and release, and you can certainly, and it may not be appropriate for you, Kevin, but you can and you do have the ability to do that if you want to. And what we do is we assess the value of your claim. We look at all the different factors, including your wage rate and your age and the type of injury that you have and the prognosis of your future medical treatment needs. And we determine whether there is a way for you to be able to get a lump sum that would be benefiting you so that either you can get treated for that injury from another source, or so that if you don't need that treatment anymore, we can wrap up your case in a fashion that's going to be in your best interests. But the value has to be there, Kevin, and you can't settle this case unless you get the most amount of money, and that's what I do for you. So the answer to your question is there's a lot of different factors that go into where you go next. But generally speaking, they can cut you off, but they have to go through certain procedures, and I will never let you be cut off unless it's something that you want to do and unless they pay enough money to cut you off, meaning make a settlement with you.
Jeff, I really appreciate that. And real quick, another question here. It goes like this. In between those years I was off, I was given a percentage of the damage of my body. Okay. One of the claim examiner said that I can get money from that, like a lump sum right away. I called and asked for it. Instead, they sent me to their doctor who gave me a prognosis of less than the percent they gave me before. How can they do that?
Let me explain that to you. What you've experienced is an impairment rating evaluation, which is different than what I thought. I thought you were just getting benefits. But if you had an impairment rating evaluation, then that means that if your percentage of whole body impairment is less than 50%, which it always will be, they only have to pay you for another 500 weeks from the date of that examination. 500 weeks, in case you didn't know, is about 9.6 years. And what these people do is they don't want to pay you 9.6 years, but that's the exposure cap that they will have after an examination like that. So instead, what you may want to consider is making a settlement where they think they're getting a bargain by paying less than 9.6 years, and you get more than what you're getting right now in a lump sum, and then you can move on with your life. But it has to be the right amount. So that's another thing to talk about to me, and you can call me, and I'll be happy to help you with that. That's an easy thing to do.
Kevin, thanks for calling Court Radio, friend, and have a great Sunday.
Thank you. Y'all do the same.
All right. You know, a lot of confusion over workers' comp, and there's a lot of anxiety when people have a new claim. We talked about some areas where I think that folks are taken advantage of, you know, with the nurse case manager or the harassing employer. People get benefits. They get, you know, Blue Cross, Blue Shield. They have certain benefits. Do those benefits have to continue after you're out on comp?
Very good question, Dean.
And you're going to give a very good answer.
Yes.
But after this break,
Oh.
because we have sponsors.
Of course.
You might even know one of them.
I might.
And those sponsors want to be heard. And folks, in 2 minutes, Jeff's coming back. We're going to talk about answer to that question. If you've got a workers' comp question, you know where to call. We'll be waiting for you. We'll be right back.
You were just hurt. It's not your fault. You're in physical pain. How do you get better? Who is going to help you recover? West Philadelphia Associates has highly trained doctors and staff that can help you today. Don't wait at a hospital. West Philadelphia Associates will work with your attorney, providing documentation of all injuries and the best plan for treatment to get you back to the life you deserve. With diagnostic studies to better detect injuries, West Philadelphia Associates doctors and staff will help you recover. West Philadelphia Associates, here to help you get better because you deserve it. Call 215-471-4714.
For 20 years, Center City Medical Center has provided premium expert medical services for Philadelphia. Whether you need musculoskeletal rehab or an immigration physical, call 888-945-EXAM. Our board-certified physicians have more than 80 years' experience from post-injury rehab to DNA paternity testing. To make an appointment at one of our 3 convenient locations, call 888-945-EXAM. Get premium expert care. Center City Medical Center, serving Northeast, North, and Center City, Philadelphia. If you've been injured on the job and are entitled to workers' comp, you need someone fighting for you from the start. Call Jeffrey Gross, attorney at law. Don't rely on your employer or insurance company to get it right. Call 215-512-1500. If you're entitled to workers' comp or it's being challenged, Jeffrey Gross can help get the money you deserve, and he won't get paid unless you get paid. Call 215-512-1500. Jeffrey Gross, attorney at law, representing Pennsylvania's injured workers for more than 20 years. You've had an accident and can't work, but your legal case seems like it's taking forever and the bills are piling up. At ThriveVest.com, we're here to help. If you have a pending lawsuit, call us at 888-697-7352. ThriveVest.com has flexible solutions to get you money now. And if your case doesn't settle or you don't receive an award, you owe us nothing. Call 888-697-7352. ThriveVest.com. Get the money you need to get on with your life.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Good morning and welcome back. This is Court Radio, and I'm joined in the studio on February the 21st with my friend and colleague, Jeffrey Gross.
Good morning, Dean.
Hi, Jeff. You know, if Jeff's here, ba-boom. If Jeff's here, we're talking workers' comp. So if you've got your workers' comp questions lined up, now's the time to give us a call at 215-227-2727. So where did that slip go? Did you throw that away? Gone. Okay. Let's talk to Brian from Port Richmond, who's got a medical malpractice question. Hi, Brian.
I got a question for you guys. My mother passed away November 12th. She checked into the hospital. She had fluid in her lungs, and she was in there for a couple months. They told us that she would be home the day that she passed away. They said she had a massive heart attack and they couldn't resuscitate her. But then the nurse said to us while we were in the room that she caught a bacterial infection while she was there. Is there anything I can do about that, or is it just...
Well, okay. Here's the answer. First, let me tell you that you have a 2-year statute of limitations. And so... 2 years from November, whatever the date was, you got to do something. Secondly, yes, you can always have the care that your mother received reviewed by specialists in medical malpractice who would hire doctors of a similar specialty to review the medical records to see if there was any negligence. Let me say that, you know, when folks go to the hospital, they get infections. That's a unfortunate but a consequential damage that occurs when you're in a hospital. Even the cleanest of hospitals have bacterial infections running rampant in those hospitals. And so getting an infection while you're in a hospital by itself is almost never going to be a valid claim. Now, I say almost never because I can envision a situation where some, clearly infected material is brought into the hospital by the doctors or nurses, and they create an unnecessary risk. Putting that aside for a moment, getting an infection in a hospital isn't negligence. However, once you have the infection, if you have signs and symptoms of an infection and they do nothing about it for a long enough period of time that a ordinary infection goes crazy in the body and becomes a life-threatening infection, that might be a different scenario. But when you're an elderly person and you're in a weakened and compromised position, an infection can kill you, even if it's handled properly. It can fulminate quickly, and it can overwhelm the body. And so you would need an infection that went untreated for a long enough period of time that what was easily treatable becomes something untreatable and deadly. And so what people would be looking for in those records is a history of high temperatures, dehydration, not eating, things that show, hey, this person is sick and getting sicker, and we didn't do anything about it for a long period of time. And if we had done something about it, their scenario would have changed drastically. And again, the older the person is, the more difficult it is to show that, because when you're in a compromised situation and age is against you, it is not uncommon for there to be an outcome like happened with Mom. But again, you ask me, can I do anything? And the answer is, of course you can. You can have the medical records reviewed. You can get the medical records, and you can have them reviewed if you still have serious doubts that they... Now, also, let me say this, one last thing. I have heard 1,000 times in my career people say, hey, they said Mom was going to come home that day and she was going to be fine. Well, that might have been their expectation, but sometimes this is a moving target and things change rapidly. And merely because they thought she was going to be fine doesn't make her fine. And it doesn't mean that because things didn't go the way they told you it was probably going to go, that there was negligence. You have to show that they did things that brought about her death in a fashion that was really not necessary. That if they had only paid attention to the details, Mom would be healthy and alive today. And if you could show that, then you have the basis for negligence and causation. But if you don't have that, all the promises they made in the world mean nothing. Okay? Because things change rapidly.
Okay. All right. Thank you for your time.
All right. My pleasure. Have a great Sunday, and my condolences to your loss.
Thank you. Take care.
Take care. 215-227-2727. Let's talk to Christine from Alany. Hi, Christine.
Good morning.
Good morning to you. Good morning to you. So
Hi.
what's on your mind this morning?
Oh, I just heard you talking earlier, and I'm not sure I understood what you were saying about if you get hurt on your job. I heard you say something to the effect of seeing your own doctor. But there are notices posted at work that tell you where you have to go if you get hurt on the job. So I guess my question is, if you hurt yourself on the job, do you have to go to the workman's comp clinic to be assessed, or can you go to your own doctor to be assessed?
So, Christine, let me answer that for you. First of all, if there's posted doctors, there has to be a compliance with the law in order for them to perfect their ability to have you treat with their doctor. First of all, they have to get you to sign a form that says that in the event you have a work injury, not only do you have to notify them, but you must treat with one of the following doctors for a period of 90 days. So if they have you sign something that is something to that effect, and they do have a list posted, then you must treat with their doctors for the first 90 days, or the workers' compensation carrier will not pay for it.
Now,
So
let me just jump in for a second because there's a list of these doctors, not one.
correct.
How many?
6.
6. And they're going to be probably from, decent to bad to horrible in how they handle the care that they give. So some of those doctors are going to be better than others. Jeff knows every doctor in the world.
Not in the world. But I know lots of the doctors that are on those lists and lots of doctors in the city, and I have good rapport with those doctors.
So some of those doctors, he might say, nah, you can't ever see this one, but you can see this one because they'll give you a fair shake. They'll really try to help you.
Or you don't have to see any of these doctors because they never got you to sign the form that makes you go to these doctors. Just because they post them doesn't mean you have to go necessarily.
So, Christine, the answer is maybe you do, maybe you don't. But, and maybe somebody could help you pick one of those doctors who might be better than others. Bottom line, having an advocate like Jeff Gross, my Philly lawyer, having an advocate to represent you in this very trying time is key to success.
And one more thing. Remember how I said the workers' comp carrier does not have to pay for the doctors that are not on that list? Well, if the doctor is not on that list and you have private health insurance or any health insurance, you can use your health insurance. You just can't have it paid by the workers' comp carrier. So do you have to go to that doctor? No. But every case is different and every circumstance is different, and you should run the scenario specifically by me so that I can steer you in the right direction.
Helpful, Christine?
I'm thinking that the form that they get you to sign is something that they do when they hire you.
That's correct, and also when you're injured. Twice they make you do it.
Oh, so when I'm injured, I refuse to sign it.
They should have made you sign it when you were first employed, and then when you get injured, they can make you sign it without you even realizing it. By when you go to the doctor, they, in fact, have you sign it there, and you think it's just part of their thing. So you have to be careful about what you're signing, and you need to read it and run it by me so I can steer you in the right direction.
Okay. All right. Well, thank you, guys.
Christine, be well. Thanks for calling. Great questions.
All right.
215-227-2727. We're talking comp. All right, we got another caller, but before we go to the other caller, let's slide back into, hey, I'm employed. I got all these benefits. I'm out on comp for 2 months. All of a sudden, my employer says, your benefits are cut. Can they do that?
Which benefits, Dean? Are you talking about health care benefits or are you talking about workers' comp benefits?
Health care benefits.
Well, health care benefits and workers' comp benefits are different. Remember, if you get a cold or you hurt your foot or you have something that's not related to work, you're covered by health insurance. But if you get injured at work, you're covered by workers' compensation insurance. The difference is that after you've been out for a period of time and your employer gets sick and tired of paying for your health insurance, they can say to you, hey, we're stopping your health insurance. And if they do, there's some rules that govern that. If the employer has larger than 50 employees, if they have more than 50 employees working for them, they can't just cut it off. They have to give you something called a COBRA letter. And a COBRA letter is a federal mandated law that says that if they want to stop your health insurance, they have to give you the right to purchase that same insurance at the same cost that the employer was paying for you, so that it's much cheaper than if you were to go out there in the marketplace to buy insurance, because that's what employers do. They get economies of scale. They get cheaper health insurance because they have so many employees. They get a better rate than an individual that's going out there into the open market to buy health insurance. Now, if it's a smaller employer, less than 50 people, they don't have to abide by COBRA. They can simply say, hey, there's no more health insurance for you, in which case you are limited to the workers' compensation insurance for your bills.
So anything related to your work injury, they got to pay as long as you continue to suffer with those injuries.
Correct, unless they don't accept the injury, obviously.
Obviously. But benefits unrelated to the injury can be cut off.
They can, and they often are. And there's ways around things. So, for instance, you can go to the Affordable Care Act website, which is www.healthcare.org, and you can compare what you've been paying for health insurance or what's been given to you by your employer with other health insurance benefits and plans that are out there. And by the way, it's open enrollment still, so you can do it now. And if you can find something cheap, which is what we call the Affordable Care Act, otherwise known as Obamacare, which benefits everyone, you will be saved in that fashion.
Let me ask you something. I just had a thought. And if you are out on workers' compensation and you have these benefits, your employer can take them away at any time.
Well, like I said, there's rules, but yes, they can stop those benefits, those health benefits.
Okay.
Not your workers' comp benefits.
Right. All right. Let's talk to Evelyn from Chester on line 4, Larry. Hi, Evelyn, and welcome to Court Radio.
Hi. My name is Evelyn, and I work for Chester Upland School District. I had a fall in March of 14, the year 2014. They sent me to workman comp for 2 months. Then workman comp wasn't doing anything for me, so they sent me to their specialist. I went to their specialist. He checked me out for like 2 weeks, so then he put me out of work. He said I couldn't walk on my foot no more. Now, this is their specialist. Okay, I had surgery on my foot, and I went to court twice. The union appointed me a lawyer. I keep calling my lawyer, but my union appointed, and he said really nothing he can do. He submitted all his papers. That has gone on 2 years now, and still I haven't gotten anything from, workman comp.
Wait a second here. Whoa. Their own doctor, their own doctor put you out of work, and they won't pay your benefits?
Yes.
Something doesn't smell right, Dean.
So
I know.
So, you don't have to get legal advice from a union lawyer who has maybe thousands and thousands of potential clients through the union. You can get legal advice from private counsel like Jeff Gross, who will look at your case, who will examine everything with his own eyes and get right back to you. And in fact, Jeff's so good about it that if you become Jeff's client, you get his cell phone and you get to call him whenever you want. It's crazy, but he does that. And
I'm just crazy.
So, Evelyn, give us a call tomorrow morning at 215-227-2727. You'll be down in the office the same day if you need to be, and you'll be Jeff's client, and he'll take care of you.
Okay, 227, the same number, 2727. And Jeff?
Yes.
Yep.
Okay.
That's it. That's what you do. All right. We'll see you tomorrow.
Thank you.
All right, Evelyn.
Bye-bye.
Chester Upland School District.
Lots of cases against them.
Yeah, who don't you have lots of cases against?
The federal government.
Right. Because those are weird workers' comp cases.
They are.
Okay. Everybody who's employed by anybody but the federal government can be Jeff's client. Let's talk to Karen from Mount Airy, who's got a workers' comp question. Coming fast and furious now, Jeffrey.
Okay.
Hi, Karen, and welcome to Court Radio.
Good morning, gentlemen.
Good morning.
Good morning.
You are wide awake, Karen.
Yes, I'm wide awake. I just got off work.
All right. Well, so at least we know that you're not injured because you just got off of work.
Oh, I'm injured. But I'm working.
Working with an injury.
A real trooper.
I'm working with an injury.
Tell us about it. What's your question?
This is an ongoing workman's comp since 2010. Since 2010 is when I got hurt.
Did they recognize the work injury?
Yes, they did.
Okay, so tell me what your situation.
But this is what has happened. Every time, I had a hearing. The judge ordered 500 weeks for one part of the injury. A second part of the injury wasn't diagnosed for almost 24 months.
So
that part of the injury is what I'm supposed to be treating for now with physicians and doctors. What happens
wait a minute. As the moderator, I have to do this. It's unfortunate. Stay on the line. We're going to be right back after this 2-minute break.
You were just hurt. It's not your fault. You're in physical pain. How do you get better? Who is going to help you recover? West Philadelphia Associates has highly trained doctors and staff that can help you today. Don't wait at a hospital. West Philadelphia Associates will work with your attorney, providing documentation of all injuries and the best plan for treatment to get you back to the life you deserve. With diagnostic studies to better detect injuries, West Philadelphia Associates doctors and staff will help you recover. West Philadelphia Associates, here to help you get better because you deserve it. Call 215-471-4714.
For 20 years, Center City Medical Center has provided premium expert medical services for Philadelphia. Whether you need musculoskeletal rehab or an immigration physical, call 888-945-EXAM. Our board-certified physicians have more than 80 years' experience from post-injury rehab to DNA paternity testing. To make an appointment at one of our 3 convenient locations, call 888-945-EXAM. Get premium expert care. Center City Medical Center, serving Northeast, North, and Center City, Philadelphia. If you've been injured on the job and are entitled to workers' comp, you need someone fighting for you from the start. Call Jeffrey Gross, attorney at law. Don't rely on your employer or insurance company to get it right. Call 215-512-1500. If you're entitled to workers' comp or it's being challenged, Jeffrey Gross can help get the money you deserve, and he won't get paid unless you get paid. Call 215-512-1500. Jeffrey Gross, attorney at law, representing Pennsylvania's injured workers for more than 20 years. You've had an accident and can't work, but your legal case seems like it's taking forever, and the bills are piling up. At ThriveVest.com, we're here to help. If you have a pending lawsuit, call us at 888-697-7352. ThriveVest.com has flexible solutions to get you money now. And if your case doesn't settle or you don't receive an award, you owe us nothing. Call 888-697-7352. ThriveVest.com. Get the money you need to get on with your life.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Good morning and welcome back. It's Court Radio, and we're doing a workers' compensation program because I'm joined by my buddy Jeff Gross. And we still have, I think, Karen on the line 2. You still with us, Karen?
Good morning.
Yes.
Yes. As I was stating, it's a prior injury. I was ordered 500 weeks of compensation for it. But what they do now is I've noticed that they will do a utilization review after maybe 9 months. Then they stop payment to my service providers. If the service providers are not getting paid, they stop the treatment.
So, you said you had a lawyer, right?
So how do I...
What? Okay. Jeff had a question. Do you have a lawyer?
Yes, I do, but I'm not satisfied with him because I've only seen him 3 times.
Three times in 4 years.
That's a lot. That's not very much at all. You really. I mean, I hate to say get a second opinion, but get a second opinion. Let me tell you. Let me tell you a few things
I need a
about.
second, a third.
Let me tell you a little something about what you're going through. There are some times where what you've been through is an impairment rating evaluation, and they've capped your benefits at 500 weeks for the accepted injury, but you might have something that's not part of the accepted injury, and that may be the reason why you're not getting that addressed properly. And if it's not part of the accepted injury, it's not going to be covered, and you only have a small window of time to make sure that gets covered. It's 3 years from the date of your injury to file a claim. In some circumstances, you may have filed that claim, but they're performing what we call utilization reviews. And by the way, if they do a utilization review on one of your doctors, you're right. They don't have to pay that doctor during the pendency of that utilization review, which could take a period of time. It could take 60 to 90 days or maybe even longer in some circumstances, depending on who appeals it. However, if they're not paying the doctor and the doctor says, you know what, lady, I'm not going to treat you until I know that I'm going to get paid, guess what you can do? You can go to another doctor. And if you go to another doctor, the utilization review that was done on the first doctor does not apply to the second doctor. It's very, very sound law under the Commonwealth of Pennsylvania that the utilization review is provider specific, which means that you do, if one doctor gets reviewed and it's pending and you're worried about the treatment from that doctor and he won't treat you anymore, you can go to another.
Yeah, first of all, any doctor who kicks you to the curb because he's not getting paid isn't a doctor you need advocating for you.
Correct.
And so, that goes up my crawl. But in any event, if you've got questions, you got to give us a call. Jeff will be happy to do a second review. 215-227-2727. We got to run.
Thank you.
Thank you. All right, let's talk to Sable from Southwest Philly on line 3, who's got a comp question. Hi, Sable. Make it quick, babe, because we got to get out of the studio soon. Oh, Sable. See, I picked her because she had this cool name, Sable.
I like that name. It's a good fish.
Yeah, well, when I was a kid, there was a lot of Jewish delis and old Jewish men who ate Sable. I didn't partake. No way.
It's not that bad.
Oh,
you
no.
Try it
It's
for a
too
second
fishy
time.
looking for me. I am not a Sable guy. All right. So we're wrapping up the hour. As usual, it flies by. 215-227-2727. If you've got a comp question, if you've got a comp claim, and you didn't get a chance to get on today, all you got to do is give us a call tomorrow morning, and Jeff will have you in no time. All right, real quick. Let's talk to Geraldine Mills on line 3. Gone. She wanted to compliment you.
She did?
Yeah.
That's very nice. Oh, that's so nice.
Yeah. All right. Well, compliments aside, I appreciate all the great advice you give the listeners on workers' comp issues.
Well, I thank you for the opportunity to participate in this program.
And folks, if there's a bottom line to this, it's, hey, comp claims are stressful times. It's your livelihood that's at stake. It's your ability to have a roof over your head and food in your refrigerator that's at stake.
Let me give you an analogy. If you were on a cruise ship and they said to you at the onset of your cruise, here is a life jacket and here is a lifeboat, and if there's a problem and you get into that lifeboat and we'll have somebody come and rescue you, and you get into that lifeboat and you survive that sinking of your cruise ship, and then about 3 days later you're still not rescued, you're going to start to panic, even though you're in a little lifeboat. So you're in a lifeboat right now if you're on workers' comp, but you don't know where you're going, and that's what I can do for you. I can give you a roadmap. I can help you figure out and strategize where your case is going and where you're going to be so that you have some peace of mind.
And you do that without taking any money up front.
That's right. We don't get paid, and I don't get paid unless you get paid. And not only that, it has to get approved by a judge. I can't just take your money, nor do I want to do that. So you call me, I will help you.
All right. And they're the caller Karen, who had one injury recognized but another injury not recognized. That's big thing.
That's potentially devastating if she finds out that she can't get covered for that injury because no one has done anything.
All right, Jeffrey Gross, we got to run. Folks, thanks for listening to Court Radio. As usual, I love my listeners. I'll see you next week, same time, same place.